days in jail and 2 years of probation. Do you understand the charge and the potential penalties?
I do.
Also understand that if you're convicted, it also carries with it a minimum mandatory $400 fines. Do you understand that as well?
Yes.
Count 2 alleges a misdemeanor charge of unlawful possession of scheduled drugs class D. That is a misdemeanor. That also has a minimum mandatory $400 fine if you're convicted. But the maximum penalties for that charge are $2,000, 364 days in jail, and a year of probation. Do you understand that charge and the potential penalties?
Yes.
In count 3, it's violation of conditional release class E. That's a misdemeanor. A class E misdemeanor is punishable by up to $1,000 in fines and 6 months in jail. Do you understand that charge and those potential penalties?
Yes, I do.
Okay, because one of them is a felony, I'm not going to take a plea from you at this time. That's in order to allow the state to present the matter to the grand jury to see if they can proceed on the class C charge. Next date?
March 21st.
We'll see you back here on March 21st, 2024 at 8:30 in the morning for a dispositional conference. I think that'll be for this, with the other one, for both of you matters will be heard for a dispositional conference on that time. I also have CR 24088. And in that charge, the state has filed a motion to revoke the bail that you posted and to forfeit your pre-conviction bail. Do you understand the allegations contained in that motion?
Yes, I do.
Okay. And you wish for me to enter denial at this time?
Yes.
Denial will be entered. And what's the hearing date on the motion?
March 6th at 8:30.
You'll be back in court on March 6th at 8:30 for a final hearing on whether your pre-conviction bail should be revoked and forfeited. Do you understand?
Yes.
All right, Mr. Warren, I'll hear from you with regard to bail on both matters.
Yes, Your Honor. On the new matter, we're asking for $3,000 cash bail with no use or possession of drugs, alcohol, or marijuana, search and testing upon reasonable articulable suspicion, and the same no contact conditions that she's already on with Jeff Card or Devin Hussey. Your Honor, she was released on bail, as you can see, for aggravated trafficking charges less than a week prior to this offense. That involved fentanyl, and once again, she was in possession of fentanyl during a bail check, as well as testing positive for cocaine and methamphetamine, and still having a usable quantity of methamphetamine on hand. Of note, she was also disregarding her requirement to maintain an address that was part of the original bail bond. The information presented shows that she'd been staying at this hotel for at least 4 days at that point, and no notification of an address change had been made. Worth also pointing out that the person that paid for the room was an associate of one of the people that she's supposed to have no contact with, which begs some other questions. All that considered, we're also asking that she be held without bail on the motion to revoke bail in the aggravated trafficking case. Her priors include, of course, a trafficking conviction in 2011 that she was ultimately fully revoked on in 2016, at the same point that she was fully revoked on a separate probation for a felony reckless conduct. She also has 2 BCR convictions, an OUI, an assault, and a couple of hindering apprehension convictions.
Ms. Gray?
Thank you, Your Honor. We would be asking the court to set a much smaller cash bail with respect to both cases, $500 cash. The address that she provided on the bail bond is her correct address. She was not on a house arrest or a curfew. And so the reports indicate that this was a hotel room that was under somebody else's name, and that she was only there for a few days in and out. And she was actually, the police were told that she was leaving. That's when they were trying to catch her before she left the hotel. She also had told the police she was completely cooperative. There would have been no basis for a search if she had not volunteered that she had used drugs to the police when she was not required to do so. was amount of drugs that were located, are relatively minor. Basically, it appears that there was 1 gram fentanyl and 0.8 gram of methamphetamine located in the room, and not on her person, as my understanding. She also advised that she has basically is still intending. She has she had a doctor's appointment yesterday that she was intending to go to, and she has a seizure condition. She needs to get her seizure medication. She was supposed to be picking that up, and also to re-up her Suboxone and to get a referral for counseling or treatment. So this is so the issue here is whether, it's kind of extraordinary when there's not when there's only an articulable suspicion provision for officers to basically go and, basically go into somebody's room and require and interview them about the issue when it's about when somebody's not even on a curfew or my client did call me and I spoke to the officer and I got the impression from him, and I was waiting to see the police reports, that he said that MDA had made a request based on some information they had, which would have been articulable suspicion, but there's nothing in the reports here today that indicate there was any articulable suspicion for a search. My client volunteered she was having trouble with substances as a user and was going to get help that day. So we believe that there are conditions that when she does not have the ability to post additional $3,000 cash bail, we'd ask the court to set, and her intention, she does have an individual that she can live with. She would be planning to go and stay temporarily with Ruth Colbeth at 40 Harbor Drive in Bass Harbor, and she will continue to keep the court advised of any changes of address and telephone